So, domestic law. And then we internationalize them, okay? How are human rights rules created in domestic law?
By the legislative power.
Legislative power, okay? Legislator. Any other answers?
If they exist in international law, then they are derived from international law and then incorporated into the domestic legislation.
This is a good point. So there is a circularity. International human rights have been copied and pasted from domestic law, and now they return to domestic law as international law. Okay. However, and this is something we will see today as well in the ICCPR, there are limits, especially in dualism for for those of you who did public international in the semester 1. The domestic law sets the conditions for international law to become operative, to produce results, effects within the domestic legal order. But this is a good point. Other answers. How are human rights made in domestic law, in national law?
Courts.
Courts. So the courts make the law, create law.
Parliament. Parliament.
Parliament, yeah, is the legislator. Its constitutional system provides for the means of the creation of the law. In most of the times it will be a parliament, but sometimes you have some prerogatives of the executive. It depends on whether it is a presidential or a parliamentary system. So legislator is a more general label. But should judges make the law?
Het is een beetje nieuw law, die amend existing law.
Amending existing law means you change, you make something new.
Develop it further? They develop the law, or they don't?
Yes, they develop. I mean, there are many nice words in order to hide, but the truth. But the bottom line always is whether judges should establish standards, should set new laws. What do you think? Yes or no? No?
Yes.
Yes.
No.
No. 2-1. It's Everton Liverpool.
I think they shouldn't, but inevitably
They shouldn't, but inevitably they do. Okay? There is a doctrine about that. They call them negative legislators. Okay? But yeah. Okay, they shouldn't, but in fact they do. Other approaches?
I would say that just, but in a way to control the activity of legislative process.
Yeah, but this is exactly the question. Not in the UK, where you have sovereignty, the parliamentary sovereignty, but in other legal systems, the purpose of the judiciary is to scrutinize, to limit the abusiveness of the executive. While doing that, they also set limits, they also set standards. So there is a broader question of a constitutional nature as to the interplay between parliaments, legislators, and courts. And what are the limits of judicial review? Okay? When something becomes too political, or when something should derive from an institution that has the legitimacy, the authority to make the law. Or in which cases, judges, unelected people, should be able to say, no, this is the point. this is how things should be. This is a huge constitutional issue, actually an issue of political philosophy in all liberal democracies. Okay? Who makes the law? An international law. States. Anyone else?
International organizations, like UN.
Yes, you have. I'll put it here, but I'll put it in the parentheses. Why? Because IOs are made by states, they're given competencies by states, and you have this endless debate regarding the autonomy of international organizations. When we should treat them as an independent, autonomous legal person that has its own capacity to create laws, or when we should pierce the veil and look behind the institutional apparatus, the curtain, and attribute this to states. Okay?
In that case, International Criminal Court, or tribunal.
The International Criminal Court is a good case because it is an international organization.
But it has autonomy to create new law. Like the
Does it have the autonomy to create law?
tribunal in Yugoslavia?
Tribunal for Yugoslavia is something different. It's not the International Criminal Court. Okay, it's the ICTY has been created by the Security Council, so it is a secondary organ of the UN.
It's the International Court.
The other is an international organization, but both examples, they are both parts or independent international organizations, and they are what else?
So judicial bodies of the
Judicial, so they are courts.
Yeah.
The same as here. So, the same debate regarding the limits of judicial activism, the limits of judicial review, apply in both international and domestic law. And this is a discussion we had last week, you missed it unfortunately, on moral philosophy, principles versus consensus of states. You remember the debate last week? What are the bases, the criteria, the methods that should be employed by courts when deciding about new human rights standards? Whether this is the job of courts, whether they should refer to states and what they do, state practice, or whether they should say, well, for me this is a matter of human dignity. What is human dignity? My personal approach, my very subjective understanding of dignity. Okay? So, what about this here? Are human rights a matter of parliaments and majorities in the society, or they are a matter of state will? Should human rights be made in a different way in domestic law and in a different way at the international level? Aren't they the same? Inalienable and universal and all these nice words that you can... If they are this thing, that kind of approach, then one of the two is mistaken, one of the two is wrong, or both of them. The right to life cannot be made in a different way at the international level and in a different way at the domestic level. Gay marriage shouldn't be constructed in a different way at the domestic level and in a different way at the international level. What do you think?
I think the creation of human rights is a political thing, so what's human rights in, say, Britain is not human rights in China.
Mm-hmm.
There's no universal norms there.
Okay, so am I right to understand that what you suggest is that we have actually two types of rights? We have rights which are universal.
Well, I think the rights are the same, but the interpretation of what a human and what the art is different, is argued. I mean, I argued that the Soviet Union and Germany and Marxist states did not accept that the individual was the ultimate unit in the law in regard to human rights, but it was the state, it was the community, it was the society that was the sense of
The right holder, yeah. Okay, let's, okay.
I know it's kind of weird.
A parenthesis. Let's leave this aside because, yes, you're right. What we're discussing here and the way international human rights are understood, they reflect a very particular political model and political understanding. Okay, this is liberal democracies. If we move away from that framework, then you have different philosophical premises, different understandings, etc. Okay, so let's leave this aside. But if you say that in China and in the UK we have different human rights,
Yeah.
yes, definitely, then this means that there are some human rights that are created through domestic means, and there is another category of human rights that are universal, and they are created by the means of international law. Is this what you had in mind?
No, I'm not saying that I would say the human rights, the Universal Declaration would be the gold standard, and everything else is interpretation.
Mm-hmm. Okay.
I was going to say a comment about what he said, but to say we're going to leave that aside. Is that if you think that human rights should be different in a different society, I would say then that you are classifying the humans with different qualities. And I don't think humans could be different. I mean, if you are here, or if you are from Britain, or if you are from China, you are still a human. So you should be able to have the same rights, even though the state doesn't have like all the potential or economic capacity to do it. You should aspire to have it anyway. So I wouldn't classify human beings in like different positions just because you're from a different country. Yeah, that's it.
Okay, I have a response to that. I think you're not discussing the same thing here, but I will refrain. I can explain you after the class. Let's leave this aside.
Mine's slightly different tangent. But if we're saying that human rights and international law is made by state will, I know that's like a debate in itself, then are we saying that the same way in the domestic system that the courts are meant to limit the legislator and limit their powers and set the boundaries, that the courts in the international system are also that role is to limit state will and to set the boundaries?
This here, excellent point. So this here translates into a dilemma between parliaments and courts, or parliamentary sovereignty and the limits of judicial review. This one here translates into a debate between sovereignty versus judges versus judicial review. Okay? So in both cases we have a big question mark, which is what are the limits of courts? What are the limits of judges? What is the red line that they should not overstep, so that we don't accuse them of being undemocratic or illegitimate? Okay? And this applies in both frameworks. But I'm returning to my initial question. Are human rights a matter of state will, of the executive, or they are a matter of parliaments? If you are an international judge, should you give priority to what parliaments wish, or to whether a state has ratified or not a treaty? Are human rights an issue of majorities and democratic participation, or they are an issue of the executive? Because if you tell me that this should be underplayed, underestimated, limited down, then this goes again fundamentally against the logic of international law. Going back to what we were discussing, we have integrated a foreign body in international law which is incompatible with the DNA of international law. Because the DNA of international law initially was state-centric. But now you have introduced something which is incompatible with sovereignty. So, to what extent we should rely on state will for human rights? That's my question.
Ultimately, isn't the executive if the executive represents state will, then aren't they the representative of the people? Whether it be elected government or not, there is some sort of representation there.
Ideally, if the state is a democratic one,
Yeah.
which doesn't apply for many states in this world.
Yeah.
In that case, yes, it is fine. And this is why in the case of the European Court of Human Rights, in the case of consensus, it doesn't really need to distinguish between the executive and parliaments or the practice it takes into account.
Because all the European nations are elected.
Most of them. And implicitly, if you discuss with judges, they will tell you they give much more weight to to the practice stemming from Germany or Sweden or the UK than practice stemming from Azerbaijan or I don't want to name countries, but you see my point here.
So from whose perspective are you asking the question, whether we should?
The question I'm asking is a very simple question. What is the foundation of human rights and international law?
Values. Values.
Various, such as
Others.
actors. Sorry, I don't understand.
Ethic.
Ethics, morality.
Yeah.
This goes back to judges, and we have this debate that we did last week as to whether we should rely for the interpretation of human rights on principles. And what I tried to prove to you was that there is no single understanding about these principles. We have different principles that they are conflicting, and within the same principle, different people will have different perceptions. So it's a big question mark with regard to legitimacy, the legitimacy of judges relying on their morality. Because for you, abortion might be something bad, and for me, it can be something good. Okay?
But I feel like states would normally, any society, democratic mostly, would have constitutions, and in those constitutions they would have a Bill of Rights, and then that would be complemented by treaties that they ratify at the international level containing some of those provisions as well in the constitution. And if they feel like there is certain provisions that they don't prescribe to, then they can make reservations or exemptions to those. But normally what is already in the constitutions will be supplemented by the treaties that they ratify. So that
This works very well in mainstream cases. Okay, so what you're doing here is you have a blender and you put everything inside. Then you blend it and you say, yeah, this is it. Okay, this is very good for mainstream things. No one will disagree that there is a right to life, and we do not really care today if the right to life stems from international law, domestic law, if it is states, if it is... as humanity, we have an agreement, a consensus that this is it. But when it comes to issues we were discussing last week, The limits of religion, very political. Issues about when life begins, abortion, euthanasia, morally sensitive issues. We have someone who goes before a court, and the court needs to make a decision. Either they will do it ex cathedra, they will say, well, I'm a good Christian, I'm a good Muslim, I'm a good, I like Nietzsche as a philosopher, and this is my decision. Or they will try to rely on something different. Legislator, should it be a question of majorities, or it should be the executive? If you tell me that this is not acceptable, then there is a fundamental incompatibility with human rights, with international law. Why? Because international law is made by states. So, what do you think? Okay, I think there are two categories of people in this room. People who are really sleepy, and people who are trying to come out with a good idea, and they're really struggling but not making it. Those who are not sleepy, let's smile. Not sleepy?
1 o'clock.
Huh?
It's at 1 o'clock.
1 o'clock, okay. In the morning.
It's like, yeah.
Lots of drinks. I think the reason why I struggle with it a little bit, I think, is just because I'm just thinking about it within the UK, and the thing is, in the UK we have both an elected legislator and the executive come from the legislature.
Mhm.
So they are elected. So that's why I'm getting a bit. I find it a bit tricky to get my head around.
Because this is
Because for me, the legislature and the executive are very similar because they're just elected MPs.
I fully agree with you. Plus, another argument is that most states, not all, but most states, will ratify a treaty, which means that it will go through a parliament. But still, there are. This does not concern so much international treaties. Okay, why? International treaties. You have usually this interaction between parliament and executive, and it is quite clear, either I want to be bound or not. This concerns mainly two other scenarios. First one, international custom. Okay? Whose practice should I take into account? The executive or the judiciary? Second, judicial interpretation. Like the consensus method that we discussed last week. What are the ingredients of consensus? Where should I look for consensus? Referenda, direct democracy, parliamentary decisions, acts, or acts of the executive? Another question in terms of judicial interpretation. Should I stick to the original will of states? Or should I allow evolution on the basis of ingredients collected from the legislation, national courts, etc.?
The reality in international law is that states are still the center of everything. So we need the will of states in order to actually have a new treaty or a recognition of a new kind of human right.
Yes, and then the question is whether this is a good idea for human rights. So international law, I absolutely agree, is state-centric. Okay? States make the rules. Is it a good idea to allow this happening in the case of human rights, yes or no?
I don't like the idea, but I don't think there's another option.
Well, because the human rights are supposed to protect individuals from states, aren't they? So we're saying that it's...
Yes, but if they are conditioned by state will, then a state can simply not say, well, I don't like human rights.
Well, exactly, that's the tension. So that's the issue, isn't it? It's the fact that, you know, on one side we sense that human rights are constructed to protect the individual from the state, but on the other side it's the state that's constructing human rights. So that's the issue.
But also,
That's it, there's no answer to it, it's just saying we can't reconcile it, we're just saying that's the problem with human rights.
We cannot reconcile it. But
then you've got the judges, the courts.
But you have scholars who try not to reconcile it, but to argue against sovereignty and human rights, against states, against state will. And this has an impact to a certain degree on international law, and this has to do with the humanization of international law that we were discussing. And B, this is a central question when it comes to judicial interpretation. Example with respect to the former one. What is international custom? If you don't give me an answer, I'll go for a coffee. Trust me.
Coffee cannot one book is a set of norms.
A set of norms. No, it is not a set of... What is an elephant? It has 4 legs.
It's general practice that the states believe they have a legal obligation.
It has 4 legs, a big, I don't know how it's called, and a tail. What is international custom, guys?
State practice.
It's a long time practice.
It is 4 legs with big nails. So it is not practice, it is long established practice. Which is debatable, by the way.
well, it is practice that has been propagated by states and then commonly accepted through the international community as forming part of law.
Before that, what is an elephant? An animal. What is custom?
A source of international law?
A source, a method, a source of international law. Okay? So, custom, and I'm insisting on this because some of you haven't done international law in the first semester. Custom is one of the 2 main methods, tools we have in international law to create rules. Then, yes, it is a mammal, it has 4 legs, etc., etc. So, what are the particular features of custom? It is not written, and it derives, it is created through practice by states and opinio juris. A certain belief created at some point, very mysteriously, we cannot identify it, we cannot know why, we cannot know how, when, but at some point states start believing, this, we have been doing it for a number of years. Now it is a legal obligation. If I fail to comply with it, then I have breached an international obligation. Clear? Yes? Okay. Do you know the theory of new custom? It was in the first semester reading.
Is that instant custom?
Hmm?
Instant custom.
No, not instant custom. You had this theory about new custom. So you had scholars who said, well, in the case of human rights, because human rights should not depend on state will, we are not interested in state practice. We are only looking for opinio juris. So we should have one way of making international law that applies to other rules, to all rules of international law, apart from human rights. Why? Because human rights are special. This is a category of rules, a branch of international law, a sub-discipline that does not follow the logic of public international law. What do you think about this new custom theory?
I think it sounds like a good idea, but in practice, it's not really feasible because I don't think
international, as much as it should, hasn't really taken a step away from that state-centric approach and still relies a lot on state will and on sovereignty. And just to say that it shouldn't isn't really enough for it to.
So, just to say that we are creating an exception, it is in reality indirectly highlighting. Yeah, a good point. Other ideas? Do you like this idea? Do you think that we should create a different tool for the creation of international human rights? Do you think that traditional law-making tools in international law are not good enough for human rights, and we need something which is tailor-made?
I don't think so, because I mean, all the human rights that we know already, we've got them through this system, right? I mean, like we need this. I think we need the state's will in order to actually guarantee the application of human rights. And if you said that you're going to create custom just by looking in opinion juris, if customary international law per se is just like very complicated to find and to apply, because we have to look to the courts and actually it's so difficult to actually find it. How are you then are gonna like consider what is a new custom or human rights law? How are you gonna make it provide you legal certainty around different states?
2 points. I'll come to you in a minute. I'm distinguishing. I'm separating these 2 points. The first one is that human rights are already there. This is the same idea like we don't really need to make that discussion. Why? Because human rights have now been established. We have them in international law, we have them in domestic law. Yes, this applies to 90% of the cases. But still we have another 10%, and this 10% is hard cases. It is very political. Because if you go before the generals, okay, let me tell you a story. I will not name the guy, although he's a famous professor of international human rights law, okay? From Finland, male, tall, he was teaching at the Europe. No. So, this guy was appointed in a committee of the United Nations as a special rapporteur for terrorism, okay? He went before the General Assembly, where you have all representative states, and of all other things that you can, think of regulating with regard to terrorism, his idea, I don't know why, was to introduce gay rights in the soft law instruments they were creating. The result, he's now only a professor, no involvement with the United Nations. Most of the states reacted. Why? Because these are European ideas, these go against our religion, these go, etc. Especially Arab states were really furious at him. So my point here is that in that kind of cases, because these cases are really political, it is not just about a man and a man being allowed to be married, or a woman and a woman. It is cultural identities. We are this, we are not like you. Okay? It has very deep political roots. It is a question of identity. So we need, as scholars, to think of these questions and try to provide answers that make sense, that are legitimate. This is the first point. Your second point is, yes, how, in the end, if we take, so custom is practice and opinion juris. If we eliminate this, you're saying, okay, how we are going to operate only on the basis of the opinion juris. I keep this is a very legitimate, a very good question. We will consider it in a minute.
I was kind of just going to say what you said, like the idea that human rights, the idea of them is kind of around, but actually it's only like the right to life and prohibition from torture and the obvious ones that are actually defined, but within society, most of them are very morally sensitive and actually they're not already there and they haven't been made through that system, so maybe there has to be another approach to do that, because these new, now that the basic human rights are there and accepted, there are so many others that are disputed that there needs to be a mechanism.
And I would add on that by saying I understand human rights, international rights like that, okay? I think that only the top part, even in the case of the most established rights, so right to life, right to family, freedom of religion, torture, even in those cases, we have a consensus only at the level of a principle. Yeah, human rights should be protected. Below that threshold, there is divergence in this world. Death penalty. Okay? Still, the world is divided. Should we apply it, yes or no? Who's in favor of death penalty here? Just raise your hands. No one? No killers?
For teachers?
Huh?
For teachers?
For teachers, yes. I would agree with you. I'm a senior lecturer, not a teacher, so...
You're making a magician.
If you would say instructors, I would disagree, obviously. So, death penalty, euthanasia, the vote case last week, when life begins, abortion, force feeding of prisoners, all the examples we were discussing last week. There is no consensus. Yeah, in principle, right to life should, yeah, we all agree. And then the question is, how we decide those cases? Do we go to an elite courts, some people who are well educated, with no economic problems, in most of our societies, men, in Europe, all of them white, not belonging to minorities, and they tell us, yes, the world should be like that. Why? Why they enjoy their Nespresso every morning from their expensive coffee machine? Or we should go back to the society and let the society decide. But if we go to the society, should majorities decide about the rights of minorities? This is the problem of human rights in general. We take this problematic area and we introduce it into international law. And we have one extra factor, sovereignty. You see what I mean? Yes? No?
Yes.
Just give me a sign. Yes? So, could we have a custom only based on opinion juris? You had this idea coming from scholars saying, well, human rights are not like other branches of international law. We cannot rely on what states want. Why? Because the very purpose of human rights is to control states. A state can say, well, of course, no state will tell you I hate human rights. They will all tell you, yeah, human rights is a brilliant idea, etc. Let me tell you another story. This comes from my professor of international law, my very first professor of international law in Greece, okay? So, he was working for the UN Secretary General, and he was sent to, I'm sorry for this, an African country where they had a dictator to discuss issues of human rights protection, etc. So they met. He was, they were very, hospitality, high standards, very warm. Of course, it was he was representing the United Nations, 5-star hotel, everything he wanted. They met with the officials, the executive, the state, no parliament, obviously. Everything was fine, etc. Then they had to draft a common text, like a press communique. And he said, okay, we will say we discussed issues about international law and democracy. The guy said, the dictator, democracy, no, this cannot be in this text. Okay, then we will discuss questions of international law and human rights protection. Human rights protection, no, we cannot. Like he said, okay, we will discuss questions about international law and état de droit, which is something similar to rule of law. And I said, what is état de droit? Well, this is the idea that you need to be democratic and you need also to have human rights and checks and balances, etc. Yeah, put it, no one will understand. Okay? You were supposed to laugh here, no words. So, my point here is that no state will you have to be a really strict, rigid dictatorship to openly say, I don't like human rights. most states will say, yeah, I like human rights. Right to life. But then we will come to a point where we will need to say, okay, are you against death penalty? And the state will say, well, I will not sign a treaty on that. Is there a custom emerging? Well, obviously not. Why? Because we'll continue practicing it. We're against torture, but it shouldn't be absolute. Why should it be absolute? Because in case of terrorists, in case of the neighbor I hate, I should be allowed to torture. So if human rights rely on states, then in reality, you don't have human rights. And this is one of the solutions suggested. Do you like it? Yes or no?
Don't you still have to look at the practices and statements of the state to establish a human rights?
Yes, so you're making excellent points. One of the big questions in custom is how this can be evidenced. And one of the problems currently, it has also been debated by the ILC a couple of years ago, is double counting. So, if a state makes a declaration, does it count for state practice or opinion juris, or both? And the ILC said that it counts as both. So, yes, some elements of opinion juris can be seen as practice, but this is again exceptional. Okay? Should we rely on opinion juris only? Should we make a tool which is specifically made for human rights?
Well, but opinion juris, there will never be any sort of global consensus because opinion juris is very subjective as well. I mean, a state may believe that it is meant or supposed to be legally bound by a certain law, and another state may feel like that is completely rubbish. So there's just no way there's going to be global consensus on that. But also, I mean, what we're debating today is the historical context to it. This International Bill of Human Rights, where you say the 90% existing, it only emerged as a response to the Second World War, so they didn't really envision the contentious issues that we're talking about today. But also that being said, there are sort of indicators in international law, like judicial bodies that sort of give us a sense of what civility should look like, or what civilized nations would apply, or what is supposed to be applicable in that sense. But just coming back to opinion juris, I don't think it would be very difficult to obtain global consensus on that, because it's really subjective as well.
Two different points here. The first one, what you were saying about these rules being created after World War II, reflecting the perception we had at that point. Now things are changing, so we should have monitoring institutions, and including courts, that they will give us the tone of civility. This is the question about the limits of courts and judicial review, how far they can go against state will, because if states wanted, they would negotiate a new treaty, they would establish a new custom. Other judges will follow what states want, and then human rights protection goes down. Or courts should find a way to update this to the living instrument logic, to the evolution dynamic interpretation logic, and give us an updated tone of civility, as you call it. Okay? But this is the debate we're having. What are the limits of judicial review? This is the first question. The second question, if we say that international law, this was the point here, is, whether we like it or not, made by states. This is the nature of the system. So we need to adapt human rights, not to adapt international law to human rights, but adapt human rights to international law. Again, standards go low. If you do the opposite, you adapt international law to human rights, you have issues like this. And this is the whole humanization debate. Humanization says, let's change international law so that it can accommodate human rights. And you have the traditional approach to international law who say, no, human rights it's the same, it shouldn't change.
But state rule doesn't operate in the same field when it comes to human rights and international law as traditional human rights law, because there are consequences for states in international law. So there are certain times where state will, for example, if a country makes a reservation to a treaty that's supposed to eliminate the discrimination of women, I mean, that its will is not to be bound by that treaty, but then it can't exist in international law whatsoever. There are going to be consequences to that state. So I think, in practical sense, what we're talking about here is...
But the sovereignist approach will tell you, no, there cannot be consequences against the state, because the precondition for the state to face consequences, to suffer the consequences of, is that it has consented to be bound. And when the state makes a reservation, if you find that this reservation is invalid, then the state should not be bound by the treaty at all. And in that case, human rights goes down. Why? Because the state is sovereign, and a precondition for it to be bound by human rights is that it wishes to be bound. And one of the aspects of the humanization of international law is reservation to treaties. Why? Because you had that Leuzido case where Turkey said, well, I don't want to be bound for what is happening outside my territory, northern Cyprus. And the European Court of Human Rights said, yes, but this is not any other area of international law, this is human rights. Your reservation is invalid and you're bound whether you like it or not. This is the human rights approach. This is changing international law because of the need to have human rights here. And Turkey and other states and the ICJ and scholars said, well, no, we are not going to change international law just because of human rights. The same rules apply also for human rights. In that case, human rights go there. And this is the dilemma. Giving priority to sovereignty or giving priority to human rights protection. This is another example of the humanization. So, what they said is custom. What is the logic behind that? How we make international law? Treaties, which are contracts. Okay? A state, if it wishes, it is bound. If it doesn't wish to be bound, it is not bound. What is the other method we have to create rules? Custom. So what we were doing, what we're trying to do is to find a way to bind the state against its will. What is the obstacle? State practice. Because if states continue to have death penalty, you will never be in a position to construct a custom prohibiting death penalty. If states continue to torture, then you will never be in a position to make a customary rule against torture. And if this is only left to treaties, then torture is allowed. Then there is no international human rights protection. So what they suggest is, okay, forget this is a state-centric system. We don't care about practice. We will only focus on opinio juris. And you have variations. Some people remembered that opinio juris, the original maxim was opinio juris sive necessitatis. Out of necessity. What is necessity? What is necessary? In whose mind? Judges. You have examples, of course, including the ICJ. I gave all this material, I gave it to you in the first semester. You have the ICJ who says, well, these are questions that are elementary considerations of humanity. We cannot look at state practice. We're not interested in state practice. You had the ICTY which said, well, with regard to these cases, international crimes, etc., I'm not interested in what states are doing. It's only opinio juris, meaning not of states. There is a shift, opinio juris of judges. So it is judge-made law. And the question for you is, do you prefer human rights that are here and compatible with international law? Or do you prefer human rights that are here and incompatible with international law?
Prefer higher up.
Higher up, a priest. Any other priest in this room? Another priest? I thought you had some issues with religion. This is another religion. This is another religion.
That's why I thought my dissertation would be good.
Any other priests? Okay. Any sovereignty guys in this room? You have to be one of the two. You cannot be. You cannot
When are you
escape.
going to get to pragmatic?
Eh?
When are you going to get to pragmatic?
What is pragmatic in that sense?
Does it work? Will it work? And in other words, can it be enforced?
Enforce is something different. I mean, enforcement means that you enforce the law against the will of someone. We're discussing a different question here is how the law is made. Once it is made, we can discuss enforcement. So, sovereignty people, just raise your hands. No one? Human rights people? Hmm?
Because in practice, it's difficult to, like he said, it's difficult to impose it in this state, in the culture, the human rights, like we think it should.
And this is where things become very political.
Yeah.
I mean, you have states against the European Court of Human Rights. I don't abide.
Yeah.
I am a democracy. In the UK, I have a parliamentary sovereignty. You will not tell me, you will not dictate me the human rights standards just because some other states are doing this. And this is why courts like the European Court of Human Rights create methods like the European Consensus. Why? Because they are trying to sell, in brackets, new standards to sovereigns, to states. So they are telling them, yes, there is a new standard and you have breached international law, but it is not something that I made out of my mind. It is because France, Italy, Germany and 20 more other countries are doing this. But if you go back to the origins of international law, the state will say, I don't care. I signed the treaty, and the treaty says a man and a woman have the right to be married. It doesn't say a man and a man or a woman and a woman. If you want to change it, this needs to go through a treaty amendment. This requires state consent. I didn't give you that consent. And as a sovereign, I don't care what they are doing in Austria, what they are doing in Germany, and what they are doing in Switzerland.
It's about culture as well.
Culture in what sense?
How people see things in the context.
In the society.
Yeah.
This is also something, it's the ABC case, where the European Court of Human Rights said, well, there is consensus, everyone is against Ireland, but because this is so culturally so strong in Ireland, okay, I forget European consensus. Ireland, do whatever you want. There is no answer to these questions. I'm just trying to describe here dilemmas and tendencies. Okay? I will give you some extra reading today on these questions just to help you with your essays if you choose to do this question. Okay? Anything else you would like to ask about this?
But what would you say is like the most important perception of all of these questions? Like
The most important.
well, not most important, but most popular. What like most applicable? No, any? No.
How does it work in reality? States are of course sovereign and they have the power. If a state, and this is what Sufyan was telling you, if a state doesn't like what the European Court of Human Rights does or the Inter-American Court of Human Rights does, or it will simply enough apply pressure for, it will not enforce it, it will somehow, you have this idea of judicial dialogue, national judges versus international judges. So it is a system where you have many actors and each one of them plays a role, and then it is a question of balance of power. Okay? But then courts are always mindful of the fact that they shouldn't push it too hard.
Yeah.
And states tend to react. In the same time, courts know that it is very difficult for Turkey to say, you know something, I don't want to be bound by the European Convention of Human Rights. Why? Because Turkey then will have this stigma of, someone who is not civilized, someone who is against human rights, etc. Whereas the UK can more easily say, you know something, I've been a democracy for some centuries now. I have the power, I have the legitimacy, I have the authority to tell you, make a step back, prisoners' rights should not be the way you say it. And if you push me too far, I will leave the system. And if the UK leaves the European Convention of Human Rights, this is a major problem for the European Convention of Human Rights. If Azerbaijan leaves the European Convention of Human Rights, we'll say, okay, you're a dictatorship. This is how it works if you the pragmatic approach.
So at the end of the day, it's everything political.
In the yeah, this is the bottom line of everything, I think. Yeah.
Yeah, but it feels like we're also existing in a vacuum, because I don't think that there are so many other factors in international law that would influence sort of a state being party to a treaty or a state being party to a convention. I mean, I don't think the UK would just be able to say one day that we're going to not be part of the European Convention on Human Rights. I mean, there are other factors like, you know, pressure from civil society organizations or from NGO, from the public, and that those also exist in the international law sphere. And it's very hard for me to believe that it's just a vacuum where a state can just consciously make a decision like that. And there are also consequences like sanctions, and you know, all of those are also factors that exist in the international legal sphere that influence how international law is developed.
Yeah, I mean, what I was going to say is, I keep on thinking about the Hearst case when we're talking about this, because about like the blanket ban on prisoner votes, because that seems to be the case that has then prompted the UK government to start a debate about whether we should leave the European Convention. I guess it was just like, because we were studying on the European module as well, and in that one, not only was the popular opinion in the UK in favour of retaining the blanket ban, but also Parliament had overwhelmingly voted to retain the ban before it went to the court. So you've kind of got an issue there where the court made a decision despite not taking this kind of popular opinion, the legislative opinion of the UK into consideration. And then now the UK is considering, it's started a debate. I think the Conservative government has said they want to leave the European Convention and establish the land of rights. So it's kind of, it exemplifies this kind of debate, as it were.
Definitely, yes. And as to your point, you're absolutely right. The question then is how we as social scientists we can bring all these factors, parameters, actors, the power each one of them has, the tendencies in the system, and make sense of it. And my opinion as a scholar is that there are limits as to what we as lawyers can do. What you've said is more of a question for political scientists. So you have theories like behavioral studies and prisoner's dilemma and veto play. So there are models in political science that take all this into account, and they try to make sense of it. We as lawyers, I mean, my humble intellectual ability limits at understanding the problem, observing what is happening, being in a position on certain case studies to understand why in the Hearst case this happened and what should happen, etc. But I cannot make a big theory of it. Why? Because me personally don't have the tools. I think political scientists, quantitative methods, not traditional political, have the tools to do this. But you're absolutely right that it is not one thing as a state will. Okay? Why? Because you have civil society, you have parliaments, you have institutional actors, you have courts, you have tradition, you have culture, you have a number of factors that interact, that interplay.
But again, then if we are like looking to actually guarantee human rights, then we're just like dreaming.
If you're a priest, this is a priest approach. I'm not criticizing it. I'm just saying that this is your box. In the sense that there are some people who get into this from the perspective of human rights or civil society. We don't care about it. It's just protect human rights. This is the right thing. But then when this becomes institutionalized, there are other factors that comes into play. And this is the last question I'll take on this because we need to move to the next chapter.
I was just thinking through the entire discussion that the priest approach also has great disadvantages, because if we focus only solely on human rights, the human rights are also kind of conflicting with each other. So should it not be regulated by, let's say, government, state will, other international institutions? I think it should have some borders, but I just don't want to sound like, oh, we don't have any human rights, they should be controlled. I think at some point they have to be regulated by society.
But how? Who in the society?
Yeah,
That's the issue.
Yeah.
Because at the moment we are a bit of courts, a bit of states, a bit of parliaments, a bit of civil society, a bit of public opinion, and all these interact together, and it's like in the blender. Okay, it's a mix.
Exactly, and the other approach, when we focus only on human rights, again, we have a problem, there are conflicting, and again, we're coming back, someone has to regulate it, who?
But all other have similar problems, because if it is only states, then there are no human rights. If it is only parliaments, then there are no rights of minorities or majorities. If there are courts, then this is a question of legitimacy and principles and moral underpinnings that we were discussing last week. In reality, but this is again my humble opinion, we don't have an answer as to what makes human rights. And this is the problem of all liberal democracies. If you want to work on something which is really challenging in your life, etc., try to answer that question. You will be one of the greatest philosophers if you provide an answer in this world. No philosopher has managed to provide an answer to these questions. So we know this is something good, we know, etc., and we are constantly debating, should it be here, the threshold, should it be here, should we change it? And we have actors who have part of the power and the influence. There is an interplay between them. But when it comes to international law, we have this perennial question: sovereignty and the limits of sovereignty. Okay? And what I want you to remember, and what I want you to discuss also in your dissertation, is how human rights has changed or needs to change in the way it creates rules, it creates new standards because of human rights. Okay? ICCPR, what is it?
International Covenant on Civil and Political Rights.
Okay. Yes.
It's just the international legal treaty that provides for the civil and political rights that states become signatory to, and then where civil and political obligations of states arise as relating to individuals as rights holders.
Why we call it a covenant? What does a covenant mean?
Agreement.
Huh?
An agreement.
Agreement. So, is this creating legal obligations for states? Yes or no? Yes? No?
Yes, unless there is no reservation.
Yes, and if there is a reservation, you're still bound by the treaty, but you're not bound by a particular provision to the extent provided by the reservation. Yes? So, this is an international treaty, okay? In the framework of the United Nations, it has a big number of ratifications, okay? So, a big number of states in today's world are bound by that international treaty. We have discussed the American Convention of Human Rights, the European Convention on Human Rights. These are regional. These are for a closed club. Members can only be states in a particular region. Whereas the International Covenant on Civil and Political Rights and the other treaties we will be discussing in the next 4 seminars are open to everyone, to every state in this world. Okay? Clear? Yes, no, wake up.
Yes.
Yes? Thank you. Thanks to the two of you who responded, the rest of you are still sleeping. But okay. Why to make a covenant on civil and political rights and not to make a covenant on human rights in general?
Is the CCPR the framework for it?
What is the framework for?
Framework to introduce things like the Universal Declaration,
What was the framework? Sorry, I missed this.
International Covenant.
No. What is the Universal Declaration? And who is older, the Universal Declaration or the ICCPR?
The Universal Declaration is older.
Okay.
But it is soft law.
So let's make a step back. What is the Universal Declaration?
Respect life.
What is an elephant? It has 2 eyes.
Minimum human right. The minimum human right.
And it is very strong.
It is a statement released by the United Nations General Assembly that established a core of principles that should be followed by the states in order to protect human rights. As a suggestion, it's not binding for the states. So it's just like,
Is it a statement or something?
it's declaration.
Declaration.
Yeah.
So, before that, another question. Who has done the reading? Just raise your hands. I'm referring now to basic textbook stuff. What is my point here? I'm not doing this to, you're all mature people. If you don't want to study, don't study. It doesn't. I'm telling this to you because the purpose of the seminar is to go deeper and to become more critical of things like the ones we were discussing at the first part of this seminar. But this presupposes that some general basic knowledge is already there. Okay? If you want me to come here and discuss descriptive things that we will do with undergrad students, like what is the UN Declaration of Human Rights, what is the ICCPR, what is an international treaty, is it binding, etc., I'm very happy to do it, but we will not be in a position to do the more critical part of it. So, should I presume that the general knowledge, the basic knowledge is here, or I should go back to the basics?
General knowledge is here, answer.
All of you? So, what is the UN Declaration of Human Rights?
Aside from being an elephant.
It's sorry?
Aside from being an elephant.
Aside from being an elephant.
It's a binding treaty.
The UN Declaration is not a binding treaty.
As soon as I said that, I thought that's just right. So just say it's a treaty instead.
Okay, I have in mind to ask you 3 different questions on a voluntary basis if you want to send me... first of all, did you all receive feedback for your note on Vallenatos? Yes, those of you... I had some problems with my laptop, it died. Bless it. So I want to make sure I didn't miss any emails. Everyone? Okay. So I'll send you an email today, and I'll give you 3 different questions, and I will leave it to you. If you want, you can answer all 3 of them. If you want, you can answer one of them. If you want, as the majority does, can simply enough ignore it. I'll just give it to you as food for thought. One of the questions will be a comparison between the UN Declaration on Human Rights and the ICCPR. But just to move a little bit, fast forward, I'll give you the very, very basic knowledge so that we can go a bit deeper. Until World War II, you have no human rights at the international level. Human rights, World War II, big tragedy, we realized that we need to internationalize human rights. So, the first forum is the United Nations. They go before the United Nations and they draft, in the 40s, right after the establishment of the United Nations, a document which contains a bill with some basic rights, human rights. This is the UN Declaration on Human Rights. This is not binding per se. Some people say that now it is international custom, some others say it is not international custom, but per se, formally, this is not an international treaty. This is a declaration by the UN General Assembly. So, soft law, some people say custom, but not a treaty. Okay? And then states say, you know something, we should also create international treaties. We should make it binding. And they start debating as to how they will realize this. And they make the ICCPR, International Covenant on Civil and Political Rights, and the International Covenants on Socio-Economic and Cultural Rights, that we will see next week. Why two covenants?
To separate the economy, separate the civil and political rights from the economic.
Yes, why do this?
I do know, but I can't remember.
Because they are part of a different category of rights according to the classification that we did in this second seminar about liberty and equality rights.
Yes, this is a fair point, but then why not to put them under a common instrument and say part 1, civil and political, part B, social and economic.
Was it to make it more palatable?
In a sense, yes, but what do you mean by palatable?
Well, certain things need to be separated because the civil and political rights was a big issue in the economic rights with regards to the split between the communists who said it was like, you know, this is the big issue. The economic must be bound with the political. So
this was the issue.
Separated.
So you have the Cold War, and you have one model which is Western liberal democracies, and the other one which is socialism. And for liberal democracies, the priority should be given to political rights and individual freedoms. Why? Because we want freedom, we want the state not to interfere. We want freedom of expression, we want democracy. Whereas the socialist governments, what they wanted was to give priority to socio-economic rights because the state was giving, the state was providing. So there was a dichotomy, there was a split. And Western Bloc states wanted civil and political rights, and communist states wanted socio-economic rights. And they couldn't agree. Even now, if you go in the United States, many of the socio-economic rights do not apply. Okay? Clear? So we have the ICCPR. This is an international treaty in the framework of the United Nations protecting civil and political rights. Can you give me examples of these rights?
Right to life.
Right to life.
Self-determination.
Self-determination.
Equal rights. Equal rights.
Yeah, non-discrimination. Yeah.
Freedom of religion.
Religion. Other ones?
Voting. Voting rights.
Voting rights, political participation. Yes. Other ones? Prohibition of slavery. These are pretty much the same as the ones you will find in the European Convention of Human Rights, which predates the ICCPR. Okay? Is there a mechanism for controlling compliance with the treatment, with the treaty?
The Human Rights Committee?
The Human Rights Committee. What is this Human Rights Committee?
It is a treaty body that has the power to actually hear cases when the states aren't complying with the content of the covenant. But also to hear between communications between state to state. Sometimes it is supposed to do that. And yeah, that's it.
So when they established that treaty, they also provided for the creation of a Human Rights Committee. The Human Rights Committee is a strange animal, okay? It is neither an elephant nor a whale. It's something, it is hybrid in a sense, okay? Why? First of all, the competencies it has. It has various competencies, but the main competencies. First one, provided that states have made a declaration under Article 41, it can examine interstate complaints. So one state complains against another state for human rights violations. In that case, some people say it is more like a court, some others say that it is more like a conciliation committee. It is mixed. Then they added an extra protocol, additional protocol 1, which expanded the functions, the powers of this committee, and gave it the competence to hear also individual complaints. Okay, so victims like me and you, individuals, can go directly before that committee in Geneva and make a claim against the state. And the other major competence of that committee is that it delivers reports against states. Usually 1 year after, signing and ratifying this treaty, the committee will examine your legal system and will make a report identifying problems with human rights to which you will have to respond. And then it is every time the committee invites the states, usually once in 4 or 5 years. Okay? So this committee delivers reports with regard to human rights performance in states, and this way it applies pressure to states, says, this law is problematic, you shouldn't proceed with that practice against this minority, against this social group. Okay? And the state needs to respond, and then it is to say, well, I'll change my law, but it takes some time. Or, yeah, this is not such an important issue because I think that I have done this, etc. And then interstate complaints and individual complaints. Okay? This is, in a nutshell, very grosso modo, the framework. Okay? I gave you something called General Comment number 31. What is this document? What is the legal nature of this document?
It's a multilateral treaty.
No, a multilateral treaty is the International Covenant on Civil and Political Rights. This treaty, through this treaty, you have established the Human Rights Committee. The Human Rights Committee has delivered this document. What is the legal nature of that document? Is it legally binding? David, you want to say?
Yeah, I was going to say, I just saying, I think I misunderstood the question, so I don't know if it's legally binding, because it's just been adopted by the committee. So, I don't know, like, would it require the different signatories to ratify it?
No, because this is not a treaty.
Okay, well, I wouldn't say it's legally binding, because it's just something that's been adopted by the committee.
Per se is not legally binding. So what is this document?
Well, it's just providing sort of explanatory guidance on specifically Article 2 of the ICCPR and the scope of the application of the ICCPR, Article 2 of the ICCPR.
Not only Article 2, more generally, they discuss extensively Article 2, but it's more general. Yeah. So this committee, from time to time, it delivers what they call general comments, which per se are not legally binding, but they are in reality authoritative. They have the authority, their authority stems from the Human Rights Committee, interpretations of the ICCPR. And it is meant to serve as a general guidance to states. So it says, you have signed this treaty. Let me tell you how I understand this treaty. Let me tell you how I read this treaty. Okay? General comment number 31 is very important because it provides the general framework of function of the ICCPR. Clear? Okay. Do you all have it in front of you? What I did is I read it again, and I have highlighted a number of points. And then I transformed these points into questions. So what I'll be doing, I have something like, I don't think we'll have enough time, but I have something like 10 points here, taken from this document. What I'll do is I'll ask the question, and I want you to give me an answer on the basis of what is written in this document. Okay? So, this is a treaty that has been signed by states and binds states. It creates rights for whom? The first question.
Which documents we looking at?
Individuals?
General comment 31. Rights for individuals, yes.
Member states?
Member states, yes. Any other right holder? And are they both individuals and states right holders?
No, states cannot be right holders, states are duty bearers.
So, are states duty bearers or right holders, or both?
They both. They both.
Both. And who are the right holders in the case of the ICCPR, or in all international human rights treaties actually?
Individual.
Only.
Yeah.
I'm reading paragraph 2. While Article 2 is couched in terms, would you pronounce it? Couched. In terms of the obligations of state parties towards individuals as the right holders under the covenant, every state party has a legal interest in the performance by every other state party of its obligations. Therefore, patati patata, a few lines below, furthermore, the contractual dimension of the treaty involves any state party to a treaty being obliged to every other state. So, this is a state. Two or more states sign a treaty. Traditionally, in international law, they are both the right holders, forget human rights, they are both the right holders and the duty bearers. Why? Reciprocity. I promised you something, you promised me something back. I have a duty vis-a-vis you, this means I have a right, you have a right, but I also have rights and you have duties, okay? But in the case of human rights, the treaty provides for the rights of the individual, which means that each state has rights for individuals as well. Each state has duties vis-a-vis individuals. So, that type of treaties, human rights treaties, establish rights for individuals and rights for other states. Both states and individuals are right holders. Clear? Yes? This is why you have individual petitions against states and you have interstate petitions against a state. Why? Because both states and individuals are right holders. Clear? Yes?
Yes.
And in that respect, if you also move to paragraph 9. The beneficiaries of the rights recognized by the Covenant are individuals. Although with the exception of Article 1, the Covenant does not mention the rights of legal persons or similar entities or collectivities, many of the rights recognized by the Covenant, such as the freedom, etc., 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 are rights which are enjoyed by individuals. Okay? So, this treaty creates obligations for states and rights for other states and for individuals. Okay? Clear?
But why does it not refer to them as rights for states as well? Isn't that creating a misconception that states also enjoy certain rights under international law?
Yes, they don't use the explicit language of a right holder or a beneficiary, because the one ultimately who benefits from that is not the other state, but it is the individual. But they say that the obligation, legally speaking, is owed both towards individuals and the state, and this is why the other state has a legitimate right to react. Okay? Question number 2. So, this treaty establishes obligations vis-à-vis also other states. Which states have a right to react in case of a breach? Every state, yes?
Because in the second paragraph it says, in the second line, every state party has a legal interest in the performance by every other state party of its obligations.
And then what it says?
And then this follows from the fact that the rules
So they give the explanation why this happens. What is the explanation?
that the rules concerning the basic rights of the human person are erga omnes obligations, and that, as indicated in the fourth preambular paragraph,
Etc., etc. So, the substantive rights, the obligations stemming from this treaty are erga omnes. What does it mean?
Obligations as well.
Obligations owed to all, okay. And what are the legal consequences of this legal quality? Legal character?
That all states can intervene.
All states can not intervene. I insist on accurate terminology.
Report. Refer. Complain. Whinge. Dance.
Very rich vocabulary. In terms of the ILC norms of state responsibility, invoke state responsibility. As a consequence of that, they can report, they can go before the Human Rights Committee and make a complaint, etc. Okay? So in reality, the interstate procedure here is an example of invocation of responsibility by states that might not be injured. Why? Because this is an erga omnes obligation. And this has to do with the enforcement. So, this treaty is a treaty that can be enforced by all other states. Why? Because all states are injured in case of a breach, indirectly injured. Why? Because this is protecting human rights, that is, values that are common to everyone, collective, general interest. Therefore, they are obligations owed erga omnes. Clear? Yes? Question number 3. What can a state do against another state in case of a breach of one of the human rights protected by the ICCPR? The answer is at the end of page 2 and beginning of page end of page 1 and beginning of page 2. And the question just
It's the procedure under the Article 41 that they can complain to the committee, and just to like raise awareness to the committee that human rights in other states have been breached, and it says about fairness of this complainant can't be like in just their own interest. They have to be actually acting as protectors of human rights.
So this is one of the avenues. Article 41 of the ICCPR provides for interstate complaints. But this covenant, this general comment says this is not the only solution. This is not the only way, the only means that are available to states in order to apply pressure to a state that breaks human rights to comply with human rights. I'm reading at the top of page 2. On the contrary, the Article 41 procedure, interstate procedure, should be seen as supplementary to, not diminishing of, state parties' interest in each other's discharge of their obligations. What do they mean by this? Is the 41 procedure the only one? The Article 41? What do they imply here? Do you understand? Link this with the erga omnes quality of the rules.
Well, isn't the response in the next line from that?
Which says?
Accordingly, the committee commends to states parties the views that violations of covenant rights by any state deserve their attention, to draw attention to possible breaches of covenant obligations by other states parties, and to call on them to comply with their convention obligations should, far from being regarded as an unfriendly act, be considered as a reflection of legitimate community interest.
This refers to Article 41, and what it says is that so we are all states. We have made a treaty that we will protect human rights. If you break the human rights in your country, you're not injuring me, okay? Because it is erga omnes, everyone has the right to invoke your responsibility and apply pressure so that you comply with human rights. One of the means to do that is the interstate procedure of Article 41. So we have established a framework, institutional framework, where me, although I'm not injured, I can sue you because you're breaking human rights. And this general comment says, okay, don't think that this is an unfriendly act, because we all aim at protecting, we all have the same values, we all aim at protecting human rights. But this is what is Article 41 doing. Beyond that, what is available to states? And this is what it implies in the phrase I read to you, that it is supplementing, not undermining the erga omnes quality of human rights.
Could it be the application of draft articles on state responsibility?
This is what they mean. So we go back to general international law. Invocation of responsibility. This was your essay question, actually part of it in semester 1. The distinction between Article 42 and 48. 42, only injured states can react. 48, any state can react if the violation is erga omnes. So, what the committee says here is that you have other avenues as well to do this. Article 41 is one of the means that allows a state that is not injured to raise the issue of human rights violations in another country. But you have other avenues as well. Okay? How often do you think non-injured states raise issues with regard to human rights violations in third countries? How many interstate complaints do we have? Or how many times had a state invoked the responsibility of another state because of human rights violations?
I don't think it's not that many. I think because if it's not in state's interest, I'm not interested in doing that.
Okay, great point. Can you elaborate on this?
No, because like I think the states are. I don't know. Maybe it's, like I can't imagine, for example, weaker states go to United States or UK and be like, oh, you breached this law. And what the United States and the UK can tell France, Germany, like a strong country.
So it is very political, and states most of the times lack the incentives to enforce human rights.
Because I think there is, even under this covenant, there is imbalance between the states, and the covenant cannot be used.
So the whole structure of international law, because it is state-centric, it requires states to enforce human rights law. Unlike human rights in other areas, states have an interest. If me and you will have a treaty that your tourists will come to my country with no visa and my tourists will come to your country with no visa, and I break my duties, do you have an interest, an incentive to apply pressure against me? Yes. If somewhere there someone is breaking human rights, do you have an interest to breach your relationship, to break your relationship, to ruin your relationship? This will have consequences. No tourism, no economy, no exchange of goods, no etc. So most of the times we say, yes, human rights are very important, etc. They're breaking them, there is nothing you can do. Clear?
No, well, I feel like because isn't that the whole concept behind community protection, community interests with international law, and human rights protection and environmental protection is one of the areas where states are sort of showing interest, even if it doesn't directly affect them.
Yes, in law, yes, and this is what the general comment says here, that in law you're entitled to react even if you're not injured. Article 41 is one of the avenues, but apart from this, you have other avenues in international law too. Article 48 of the ILC norms of state responsibility, the question of whether we can apply countermeasures or not. So there are avenues there. But what I'm telling you is that in reality, this is not working. Why? Because interstate relationship is not only about human rights. Next question. Who is bound by the ICCPR within a state?
It's binding the state as a whole. So administration, legislative, executive, and judicial is in paragraph 4.
Okay.
And other public or government authorities, or whatever, like national, regional.
So what they say is that the ICCPR creates obligations that bind the state in its entirety. The executive, the courts, and the parliament. Every time that a judge at the domestic level is failing to remedy a human rights violation, in reality it is breaking international human rights law. in reality, it is engaging the state responsibility, the responsibility of its state. Clear? What are the effects that the ICCPR is creating domestically, in domestic law? Actually, I'm thinking that I did a great job this morning. All these are excellent exam questions.
Sorry, can you repeat that question?
The question is, what are the effects produced by the ICCPR in the domestic legal order?
It is in paragraph 7. I think so. So it says, Article 2 requires that the state parties adopt legislative, judicial, administrative, dedicated, and other appropriate measures in order to fulfill. No?
It is relevant, but we discussed this in a different context in paragraph 7. But in paragraph 4 earlier, they say, although Article Paragraph 2 allows state parties to give effect to covenant rights in accordance with domestic constitutional processes, the same principle operates also so as to prevent state parties from invoking provisions of the constitutional law or other aspects of domestic law to justify a failure to perform, etc., etc. So, what in reality they mean here is that this is the legal order of the state, this is the ICCPR. The ICCPR then does not penetrate the domestic legal system. The effects that the ICCPR will produce here depend on the national constitution and the ways in which it provides for international law to become domestic law. However, states cannot use domestic law as an excuse to break the ICCPR. Clear? Yes? One more question, we'll stop and we'll resume next week. Can the rights under the ICCPR be limited? If yes, on the basis of what criteria? Paragraph 6.
They can make restrictions, but only they have to show the necessity.
And on the basis of proportionality.
Yes.
So what they say, they don't explain here if there are absolute rights or not. They're not entering into this discussion. But they say that in principle, the rights we have here can be limited, but you can limit them on the basis of the criterion of necessity as part of the broader test of proportionality. Seminar number 2. This is what we did in seminar 2. Okay? Sorry. We'll continue next week. I'll send you an email that will contain 3 different parts. One is reading for next week. The second, I want to give you some extra reading on the ICCPR, but also on the making of international human rights law. The last part, making of international human rights law, will be useful for the essay if you decide to take this question. And then I'll give you also 3 questions. These are not binding, not mandatory. So if you want, by the end of next week, not this week, send me a note, no more than 3/4 of a page per answer, so no more than 2.5 pages in total. Or if you want to do 1 note, no more than 1 note for 1 question. Okay, answering these questions. And the purpose of this is to make you to reflect, make you to think, and the third one is to also make you do a little bit of research. Okay? They are not binding. If you give it to me, I'll provide you feedback. These are meant to help you. If you don't like them, don't do it. Okay? signatures.
他有发有个题目吗？题目。
上课之前说了，然后我们是2个题目，一个就是。
你没有收到吗？
啊？
你有收到吗？
没有啊，他刚刚上课之前说的。
今天才发是吧？